Hello, everyone. Thank you so much for coming to our Implementing Cash Bail Talk story with retired Judge Mike Town, retired attorney Bob Merce, retired Judge Ron Ibarra, and Assistant Federal Defender Minda Yamaga. My name is Kylie Akiona. I use she, they pronouns, and I, along with Lee Curran, co-facilitate the Faith Action Transformative Justice Task Force. We invite everyone tonight to ask questions about cash bail, reflect on your own feelings about it, its purpose, its impacts, and how you can get involved in its reform and elimination. This event is currently being live streamed to Faith Action's Facebook page at Faith Action Hawaiʻi, and the recording of this event will also be uploaded to their Facebook page after we're POW. Our Faith Action for Community Equity's Transformative Justice Task Force unequivocally supports cash bail reform and is putting our faith in action by making it our main priority in the 2022 legislative session. Faith Action is an interfaith, grassroots nonprofit group of committed folks who believe in the inherent dignity and worth of all people, that believe in humanizing our family members, friends, loved ones, and all community members caught up in the carceral system is reflected in our work. Our mission to transformatively change the criminal legal system is grounded in care, compassion, and a deep commitment to transformative and restorative justice that will result in safer and healthier communities. I'm now going to quickly pass it over to our organizer, Kiki, to talk about some tech details for tonight.
Aloha, everyone, and thank you for joining us. If you have any questions for the panelists, please feel free to type them in the chat or raise your hand when it's time for questions. And if there are any technical concerns, please also include them in the chat, or you can message me directly. And Kylie, you can take it back.
Thank you, Kiki. So tonight, we're so grateful to welcome some amazing restorative and transformative justice advocates and leaders. Current Federal Assistant Defender Minda Yamaga, retired attorney Bob Merce, retired Judge Mike Town, and retired Judge Ron Ibarra. First off, could you please tell us about yourselves, the work you're doing now as advocates, and why you're passionate about cash bail and criminal legal reform? And Minda, could you please start us off if you're welcome?
Sure thing. All right. So greetings. Thank you for inviting me this evening. I'm happy to be here. I think I'm the only guest without the word retired before my name. So I need to start out by saying two things. One, I'm here in my personal capacity. Obviously, I'm not here as a representative of my current employer. And two, that gives me a certain perspective and that I'm still in it, but it also gives me, I feel like I'm very humbled to be in the presence of other individuals who certainly have had storied careers and have the perspective one only gains with the additional experience. So thank you for inviting me amongst this panel, and I feel very honored. My background is, I'll start just very briefly. I went to University of Hawaii at Manoa, and I got a degree in chemistry. I had no plans or desires to be an attorney. I did not know any attorneys, in my family or anything like that growing up. I went to law school kind of on a whim. I had two young children and was trying to figure out how to make a living. It was in law school through the practicum, these experiences that I learned what a public defender was. And then I decided that is actually what I wanted to do. I worked at the state public defenders from 2010 to 2015. And I've been here at the Federal Public Defender's Office since 2015. I certainly see day in and day out over my career what what my clients go through in the criminal legal system. I understand what it means firsthand from hearing their stories, why when they're incarcerated, I meet with their families, I see the repercussions, and I have developed quite a wealth of knowledge regarding, the struggles of the individuals in the criminal legal system. So thank you.
Thank you so much for coming, and it's super nice to meet you. Next, Bob, could you also introduce yourself and talk about why you care about cash bail?
Sure. My name is Bob Merce. I'm a retired lawyer. Before I retired, my practice was in basically personal injury law. I never handled any criminal cases, never had any association whatsoever, really, with the criminal justice system until after I retired. And that came about when somebody asked me to help an inmate get compassionate release who was in Arizona, saguaro in Arizona, and was dying. And I helped him, and then the phone started ringing all the time with other people calling and saying, I heard you help this one guy. I got the same problem. I've got end-stage liver disease or stage 4 cancer, and can you help me? And so I kind of found a new way to spend my retirement, and that's what I've been doing. And one of my real passions has been trying to stop the state from building a huge new jail. And one of the key ways to do that is to look at bail reform. And bail reform is the primary way, really, we can shrink the jail population and stop the flow of people into the jail. So it's just such an important component of any type of criminal justice reform that you can't avoid it. And so I've tried to study it, but it's important to say just that I've studied bail, but I've never, like Minda, I've never been in court asking for bail or seeking bail or dealing with bail. And I've never been on the bench like the other two panelists, Judge Town and Judge Ibarra, who dealt with it every day. So the other three panelists really have the hands-on experience and my experience in bail reform. I feel really passionate about it, but it's more academic than hands-on.
Thank you so much for sharing, Bob. Mike, if you'd like to go next.
Sure. Thank you. Mike Town here. If you hear my dog, her name's Dulce, and she'll answer quickly. For the last 4 years, I've been pretty much trying to be fully retired, but I have a small mediation arbitration practice. I'm on the state prison correctional commission along with Judge Ibarra. I was on the parole board for 8 years until 2018. Got to see all 9 different prisons, travel to Arizona. Prior to that, I was a trial judge for 30 years, and I've had the great joy of teaching at the law school. I've had 40 law clerks over the years, and I like to call as restorative justice as my so-called interest, and I like to call myself Justice Sherpa. I don't know what that means, but I go up until my nose bleeds, and then I go back down the mountain. Thank you.
Thank you. And Ron, if you'd like to finish us off with your introduction.
Yes, I'm Ron Ibarra. I'm living in Kona from the Big Island, and I graduated from University of Hawaiʻi Manoa with a bachelor's in business administration. Went to Santa Clara Law School, got my JD there, and went to Georgetown University Law Center for my LLM. Prior to becoming a judge, I started my legal work as a prosecutor in the Big Island. Worked as a prosecutor for 6 years. I was a senior deputy and was the supervisor for the career criminal unit. After that, I did defense work for about a year and was appointed the county corporation counsel. And after that, I was appointed the managing director for the county of Hawaii before I was appointed to the circuit court bench here on the Big Island. I've been a circuit court judge for 28 years. I've been the senior family court judge, the administrative judge, and then the chief judge in 2000 until 2017 when I retired. I sat on both criminal and civil cases. I served in the military, both in the active Army and Reserve, and I was discharged as a lieutenant colonel in the Army Reserves. I presently serve on the same committee like Judge Town does, the Commission on Corrections Oversight. I served on the Access to Justice Commission, Judicial Administration, Initiatives to Enhance Civil Justice, Hawaii Justice Foundation, Hawaii County Liquor Commission, and my favorite job is volunteering at the Pro Bono Self-Help Center. I I am passionate in bail reform or reform in the criminal justice system, although we have a pretty good criminal justice system regarding jury trials in the United States. But our bail system is one that needs reform. I'm not saying that it's a bad system, but certainly it can be improved. And anytime it involves incarceration of a person, a deprivation of a person's freedom, I'm really concerned. As a trial judge in criminal cases, I saw it happen in practice, actually. The bail system discriminates, and it has been said, it's common knowledge, it discriminates against the poor, and as an extension, because generally the minorities are poor, discriminates against racial ethnicities. And certainly I've seen it happen where a defendant who is poor, homeless, is set a bail amount that basically is meaningless. You might have set it for no bail because the person cannot post any money. And, so I've seen the disparities, the injustices, the inequities, the unfairness, and certainly I'm interested in trying to improve it to, make it better for all people. In any system, in order for a system to survive in a community, the bottom line is it has to be fair, and the community has to see it to be fair. They may not agree with it, but as long as they see it, they can agree to it being fair. I think they can support it. And in any system, to effectuate change even, we need community support. That's where it starts. Thank you.
I totally agree with that. Thank you so much, everyone, for sharing your mana'o. And with that, I think I'm just going to jump right into the main questions for today. So the first one I have, and I guess this goes more towards everyone but Bob, I guess. How does cash bail in Hawaii? Well, Bob, also you can chime in. I didn't mean that, but how does cash bail in Hawaii work today? And what have your experiences with bail been? And could you give us a rundown of what that means and looks like, if anyone wants to jump on that?
Okay, I'll go. Okay. So the cash bail, and just before this hearing today, I spoke to a Chief Judge of the Third Circuit, Robert Kim, and to see if there were any differences since when I was there. But basically, it's the same except for the pandemic, where they have to incorporate visual or phone calls, but not personal contact. So basically, when a person gets arrested, whether it's by the police or on view by the police, or based on a warrant of arrest from the bench warrant, grand jury indictment, or just a warrant issued by the court, when the person is arrested, the person is taken to the police station, of course, and at least in the Third Circuit, there is what we call a bail guidelines. So in case that and there's a statute now that allows this, in case the judge is not available to set bail, the police has a bail guideline. It's not binding. It's so that the person can be released if the person can post a bail. Now, this is where I say it's discrimination, because it's just a guideline that the police has, and that it doesn't consider anything, no financial background, no employment, no education, nothing. It's just you're charged with a crime. Here is the bail. If it's a Class C felony, it's a guideline, $5,000 or whatever it is, and that's set by the chief judge in consultation with the bar. So once that bail is set, the defendant, if he posted or she posts the defendant, is given a court date to appear in court. And the bail then is transferred to the court from the police. At the time of arraignment, the court date, the defendant received the complaint and the charges are read. The defendant if unable to afford a lawyer, is provided a lawyer, a court-appointed lawyer. After all the preliminaries are had, such as setting the trial dates and pretrial conferences and pretrial motions deadline, the court addresses the bail. The question is whether the defendant is going to be out or incarcerated. So the bail, if there is not a bail study which was provided, which was made at the time the defendant was arrested and now being provided to the court has to rely on its own judgment. But hopefully, most often, there is a bail study. The Intake Service Center, before the defendant is brought to court or a court date, would have interviewed the defendant and gotten some background, such as employment, residence, and prior record, and anything like that, the charge, of course, and makes a recommendation to the court on what the bail status should be. It could be a monetary amount being suggested, or it could be supervised release with conditions, or it could be what I call basically own recognizance. So the cash bail is the one we're concerned about, where usually the Intake Service Center personnel will suggest an amount. And of course, the defense attorney will argue the amount or no amount, or how the defendant should be released on bail. Prosecutor makes its argument, and the judge sets the bail. Now, under the statute, bail is also OR. When we talk about bail, we're not only talking about supervised release with, with conditions or conditions of release on bail. We're talking about also own recognizance. And certainly, I did allow defendants to go out even before the statute was amended for unsecured bail, to go out on own recognizance without anything. Just sign this notice to appear and you are released. And after considering all the facts, sometimes when the defendant came before me, I did not have a bail study. Nevertheless, what I would do, I would get, I'd tell the defense attorney, if you object to my questioning your client, please object. So I would ask the client, where do you live? How long you live there? Do you work? And what do you do? What do you do? And I've already had the rap chat. And so I'd ask the defendant, essentially, I'm trying to get information that would have been given to the Intake Service Center personnel in coming up with a bail study. And then if you ask me, how do I set the amount? Now that's the big question, right? Different people have different financial status, and certainly, cash bail today, which I try to avoid, is basically, I tell the prosecutor, do not use it as a subterfuge for no bail. If the defendant is a threat to public safety, you better make a motion for no bail. Don't ask for high bail, because bail in reality does not protect the public. If you think about it, theoretically, if you put $1 million bill on a person that can't afford it, theoretically, if the person gets a bail bondsman or somehow gets a rich relative or someone who can post a 10% premium with a bail bondsman, that person is going to go out. So there goes your threat to public safety. So I tell the prosecutor, do not raise high bail, because eventually what they'll do is a bail is set, cash bail, defendant somehow posts it, gets released in the community, and then what happens? Prosecutor then comes into court, asks for increase in bail when nothing different has occurred. So basically, I tell them, if this defendant is a threat to the community, come in with evidence and we'll have a no bail hearing. Now, interestingly, the statute talks about the setting of cash bail being a reasonable amount considering different factors, which I went over, just a few of them, like employment, financial status, and housing and things like that. But interestingly, if you look at the statute, we talk about reasonable amount. What are we talking about reasonable amount for? To me, cash bail should be set at the reasonable amount whereby the defendant would put down cash and be able to pay it. And that cash is sufficient enough to make sure the defendant would return to court because the defendant does not want to lose that cash. But how it's been used is basically, it's been used as a subterfuge for people to be held in jail because the amount is set so high that the defendant cannot pay it. And that's my, basically my concern is basically. So if the defendant makes the bail and does not show up for court, obviously the defendant can either have posted a cash bill by himself or through a bondsman. If the defendant posts through a bondsman, the defendant basically pays a premium to the bondsman. It was 10%, which they do not get back. If the defendant does not show up in court, the bondsman has, basically at the court date, defendant is not present, prosecutor asks for bail, bench warrant, bail forfeited. So the court grants a bench warrant for non-appearance, forfeit the bail amount. Then the bail bondsman has a redemption period, basically. The bail bondsman will go out and look for the defendant and bring the defendant to court in order to get back, the bond that the bail bondsman posted. And certainly the court can tax cost. If the defendant posts cash, basically the cash is forfeited to the state. It goes to the state coffers. Basically forfeited to the state for non-appearance. I've had my experience in drug cases where the family members post their homes, as bail, as collateral, and the defendant is right there, being addicted to drugs, and the mother or father is there, and I tell them, if your son does not show, you would lose your house. And they would look at their son and says, I don't think he'll do that to us. And, drugs today is terrible. And basically, the drugs are so terrible. They control the life of the addict, which eventually they steal from their parents to feed their habit. So what happens? The defendant does not appear. And come date, the parents appear. And suddenly, I give the parents time to get their son into court. But so that's cash bail for arrest on charges that must be filed. I'm not talking about the other. This is pre-trial detention. I'm not talking about cash bail after conviction or on violation of probation or things like that. So this is just related to pre-trial detention.
Thank you so much. Oh, God, sorry, my throat. Thank you so much, Ron, for sharing all of that. That was super, super insightful. Mike, very quickly, if you could just briefly recap, and I know you already touched on this, Ron, but just very briefly talk about the purpose of cash bail and its presumption of, or the relation to the presumption of innocence, just very briefly.
Perfect segue. I'll keep it short. I agree with what Ron said. I don't know if Ron and I are the cards that flew out of the deck, but I ran my court like that off and on for 30 years. The 8th Amendment to the U.S. Constitution, which is the moral imperative of this country, the first 10 amendments, says you can't have excessive bail. So any bail, let's say $1 if the person doesn't have a penny in their pocket, is, in my mind, is excessive. So we need to address that head on. And the presumption of innocence applies certainly at trial. I think we're aware I think we should abolish cash bail, just to go cut to the chase, except in a real odd situation. And my dog's going to make noise now. We should abolish cash bail and address these defendants individually. And most of them, I think we can we can put them out on ROR or some kind of surety that it doesn't involve cash. And then at the presumption of innocence at the time of trial, we're one of 10 out of 200 countries in the world that have citizen jurors. So it's really important that we have a fair trial where they're actually presumed innocent. The great majority of people, Minda can talk about this, but they will plead, they'll plead guilty just to get out, or plead no contest, which I think is weird, just to get out, because what they want is freedom, and they bargain away their presumption of innocence. So it's a tough, intractable problem. Thank you.
Thank you so much, Mike and Ron. Would anyone else like to talk about their experiences with bail or any other comments?
I can add just a few comments. So I have the experience of both practicing in state court and federal court, and each has its problems. So one thing that I certainly have found works in the federal system is their pretrial release program. And, so I've now been a federal public defender in federal court for about 7 years. So every time I'm reminded of how this pretrial release system works in the state, I revisit all these like emotions of, this is not how it's supposed to be. This seems like it's quite backwards. And something that Mike just said, I do want to reiterate, which is quite frequently, and I had forgotten about this because this is not how it works in federal court at all. Quite frequently, at the time someone enters either a guilty or a no contest plea, so that means they have gone from being presumed innocent to now they are admitting guilt in one way or the other to the crime that they are charged. At that point, there is an agreement that they can be released. And like, this is, when you think about that there is absolutely no logical sense to it, right? Why were the prosecutors or the system saying that when you are presumed innocent, you're too dangerous to go out, but once you are convicted or at least admitting guilt, and there will be a sentencing hearing down the road, you are then released? And that is quite frequently the practice. It's like, well, now that you pled guilty, you've taken responsibility, we're so happy you've done that, we will let you out back into the community. Obviously the person, the court often says, and this is not without merit, this is valid, says you have a sentencing hearing pending in 3 to 4 months or whatever the case may be. And, your performance now that I've let you out is gonna dictate how I sentence you. So there is some incentive, a big incentive for the person to do well during that time period. But this notion that, and that the original, whatever, if weeks or sometimes months or sometimes close to a year, while they are pending and working with their attorney and going over, trying to figure out exactly if they have defenses, how to kind of wind their way through the system, that during that phase, they're too dangerous, and that, again, that's not how it works in the federal system. In the federal system, it works much more intuitively in this aspect, which is when you are presumed innocent, it is much easier to be released from custody versus when you have then been found guilty by a jury or pled guilty, the standard changes, which is kind of more intuitive, right? You're like, someone who is innocent, presumed innocent in our system, that should be the place or the phase at which it's easier to get out of custody. And again, quite frequently in the state system, it is flipped, and people are getting out of custody once they plead guilty, which then of course puts undue pressure on them to plead guilty, to rush through, to not have these thorough conversations, to shortcut investigations, etc. So I'd forgotten about that because I'm like 7 years out of that system, but that certainly is a practice that is commonly seen. And it is, I think, a direct byproduct of the cash bail system, and it makes no sense.
I totally agree. Thank you. Bob, did you want to talk about anything?
Yeah, well, I just wanted to mention two things. One is when somebody can't make bail and ends up waiting for trial in jail, there are really serious consequences for that person's family. Let's take an adult male who's got a wife and 2 children and is employed at the time that he is arrested and he can't make bail. Chances are that family's health insurance is dependent on the employer, the employer. And if you can't go to work, you're going to lose your job, and your employer is not going to wait for you to go to trial and come back. So you lose your job, you lose your health insurance. If you lose the income for the family, you can't make the rent. You run the risk that you're going to be out on the street, literally evicted. You don't have your health insurance. You can't buy medicine for your children or yourself if you need it. People go to their credit cards and max out their credit cards just to try and survive while the breadwinner is in jail. And so it really wreaks havoc, not just on the person who's been arrested, who may be innocent and may be found not guilty. It wreaks havoc on their family and can really destroy a family. And it often burdens other relatives, because what happens when somebody is sitting in jail is you not only ask your immediate family, God, can you try and find the money for the bail? You go to all the relatives, and all the relatives chip in and try and raise the money to get 10% of the bail so they can give it to a bail bondsman, and they never get it back. And it's money they can't afford. And so, they have no chance of really, if it's let's say it's a poor person and it's a $10,000 bail, they have no chance of ever getting it. They might get 10% of it, but, they really can't even afford that. But that is gone forever, whether they're innocent or guilty, and whether bail was excessive or not. And so I've talked with Judge Town sort of almost jokingly that before a judge imposes bail that a person can't afford, there should be maybe what we call a bail impact statement, like an environmental impact statement, to think about, or have somebody look at and talk to the judge about, well, judge, here's this the family situation. And if this person is stuck in jail for, let's say, 6 months or 3 months or 5 months, however long it is, and they lose their job, these are some of the consequences. Maybe that ought to be another factor that we consider. And I think that's one of the real big problems with bail. And the second thing is Judge Ibarra really touched on this. They have this, what they call a risk assessment instrument that the pretrial the intake service center people use to make that report to the judge on what, the degree of risk that this person poses of not returning and a bail amount. And one of the questions that they ask, for example, on that is the age at first arrest. And if you're and we know that age at first arrest it correlates very highly, with people of minority groups, and in Hawaii it correlates with Native Hawaiians and Pacific Islanders. They tend to get arrested for a lot of reasons, not because they're being bad, but because of the way the system's structured at a young age, and so they go into this process with one strike against them. And it's a big strike, because that strike is one of the things that is going to be considered in determining whether you're going to end up waiting for your trial in jail or out. And another one is that there have been studies that show that if you do end up you don't make bail, you wait and you spend your time incarcerated up to the time of trial, your chances of losing your case and being convicted are much higher than if you're out on bail for a lot of different reasons. You can help your attorney more effectively if you're out. You can and you can do a lot of things. So they're just tremendous consequences. It's not simply that you end up spending some time in jail. It's that your whole life really gets kind of wrecked, and your chances of ever getting it back, because the chances of being convicted have gone up. You're really in a downward spiral that is so unfair to people and so unjust. And that's one of the reasons we need to get rid of cash bail.
That was perfect. Thank you so much, everyone. I'm going to move on to our next question, and it's talking about the current bill in Hawaii's state legislature surrounding bail reform, which is House Bill or HB 1567 HD1, which would eliminate the use of monetary bail and requires defendants to be released without bail after signing a written promise to appear in court, but only for certain nonviolent offenses and subject to multiple offenses. And it just passed through the Senate's Public Safety Committee and now needs to get past the Senate's Judiciary or JDC Committee, chaired by Carl Rhodes and Jarrett Keohakalole. What do you all think about HB 1567 HD1 and the amendments that were made to the original version of it, specifically removing nonviolent Class C felonies? If anyone would like to jump in on that, I hope that made sense. Go ahead, Bob.
This bill, HE 57 House Draft 1, it only applies to people who are charged with a traffic violation, a nonviolent petty misdemeanor offense, a nonviolent misdemeanor offense, and it has so many exceptions that the exceptions totally swallow up the rule. There are so many misdemeanor and petty misdemeanor offenses that are excluded, and the bill does not apply to, including assault, terroristic, threatening, sexual assault, abuse of a family household member, which is one of the most common reasons that people get arrested. If you look at the police reports, violation of a TRO, a temporary restraining order, an order for protection, violating an injunction, negligent homicide, of course, unauthorized entry into a dwelling, which is really common, and you look at all of these exceptions, and on top of the exceptions that apply, it says in addition to those, there are a whole bunch of conditions. There's 6 of them, and that make the statute inapplicable. And that is if you've had a history of non-appearance in the past, you have a trial pending, you were on probation or parole, you're currently charged with a violent offense. But the last one is the killer. It says that the whole statute does not apply to you if the judge determines that you present a risk of danger to any other person or to the community, or a risk of recidivism. So what does that mean? It means we're right back to the judge's discretion, and the mandatory part of this bill really doesn't apply, because you may be charged with a misdemeanor that should be non-bailable. But if the judge decides that you have a risk of danger to any other person or the community, or to recidivate, which means reoffending, then the judge is going to do what judges always do when they think you're guilty. They're going to say that I'm going to impose bail. So it's, to me, it's just, there's so many exceptions, they swallow the rule. And before today's, this morning, I looked at the misdemeanors of people who are currently in jail because of misdemeanors, and they're all. If you include all of the misdemeanors, and I think this includes petty misdemeanors and violations, it's only 12% of the total jail population. So what we're talking about is something that, if there were no exceptions, would only impact about 12% of the people who were arrested. And with all the exceptions, it's probably going to affect 2 or 3% is my guess. And so, I think it's a good idea. We need to take little steps, I guess. But to me, I've testified in favor of the bill, of course, but also, Class C felonies are so common. A possession of any amount of a dangerous drug is a Class C felony, even if it's the residue on a pipe. And so if you're charged with a Class C felony, this law doesn't apply to you, even though you may be, you may be a user of drugs, but nothing else. So I just think, I mean, I really wish they would have kept Class C felonies in, non-violent Class C felonies. But I got to say, I'm really disappointed. I hope it passes. I'll be happy if it passes, but I won't be thrilled because it just is not a big enough step in the right direction.
That's perfect. Sorry, Mike, go ahead.
Just in a footnote, which I agree with Bob, what is a felony? A Class C felony in Hawaii in many states is a petty or full misdemeanor. For example, a theft at a grocery store, if somebody pushes the security guard, becomes a rob too, 10 years in prison possibility. To take money out of a car or sunglasses out of a car is entry into a motor vehicle. That's a C felony. Depending on the amount stolen, it could be a C felony. So I think we've overly felonized. Many states have wobblers where it can be charged as a misdemeanor or felony or a straight misdemeanor. So I agree with Bob. We've raised the bar or lowered the bar so far that it takes away the rehabilitation. And then when they go to jail, we need to look at where they go. They're in a perfect college for gangs and trouble, and the jails themselves need to be rehabilitated. That's what our Act 179 that Ron and I operated under, the Oversight Commission. We're supposed to look and see if everything's going to be reformed and rehabilitated rather than punished. Thank you.
Oh, that was perfect, Mike. Thank you. Did anyone have any other comments on HB 1567 HD1?
I don't have anything to add, but I feel like I should certainly echo the sentiment that was previously expressed because it's worth echoing. And the types of Class C felony offenses I was thinking about that would be excluded from this include what Judge Town said, but also things riding a stolen moped, right? That's a UCPV. That's a felony, and this bill is not applying to that. Certainly, the definition and what Bob highlighted, which was the last disqualifier, to me is the one that absolutely stood out as the most concerning because it is kind of undefined. It's this vague notion. It disqualifies anybody that's something that can fit into that category of dangerous to what is itself or others, or risk of recidivism. I mean, to me, that's even more vague. Like, what does that even mean? It disqualifies almost everybody, even without these disqualifiers, as Bob noted, that the percentage is relatively low. And again, while steps in the right direction are steps in the right direction, the added concern that I have is that, if this is touted as bail reform and it's passed and it's like, there's this big bail reform has now passed, if that message is conveyed, then that is the wrong message. It is, the message that should come from this, if it's passed, is, one small step in the long battle for bail reform has been taken, not that this is bail reform, because this is not. We can look at it both exactly as the percentage that it will affect, the ease with which folks will be disqualified, the likelihood that the vast majority of these individuals, as that are charged with crimes that will apply, have already been released because of the other, these are just really, really petty offenses that we're looking at. There's shoplifting that it crosses a certain threshold, it becomes a felony. Those people would be disqualified. And who's shoplifting? People that don't have money. Who's shoplifting? People that are addicted to drugs and need drug treatment. These are the things that we're not addressing the vast majority of our incarcerated individuals who are drug addicts that need treatment, right? I mean, I worked with these many folks charged with crimes, and methamphetamine touches almost every single case, regardless of what the actual charge is. So I I didn't add anything, but I felt it's important to like emphasize what was previously said because it's true.
No, you absolutely added to the conversation. Thank you so much. That was really informational, by the way. Ron, did you want to add anything about the bill? You don't need to. I don't want to like pressure you. Okay, I'm going to move on to the next question then.
Yes,
Wait,
let me-
wait,
Oh,
I was
sorry.
speaking, I was on
Go
mute.
ahead.
Okay. Let me look at what Bob says and what was said about the disqualifier, about the judge's discretion. I look at that as positive. More so with that disqualifier, Class C felony should be added.
Yeah.
Because if anyone is afraid that these Class C felons will commit crimes or high risk, the judge has the discretion to say no. So I look at it that way. I hope the bill passes because as background, as commonly known, this started last year in Senate Bill 1260. We went round and round and round, and now I think we're going to have something. And as has been said, big changes start with small steps. And certainly, I would hope it passes, and we can show that it works, so then more modifications from what we start with can happen.
Oh, that was perfect. Thank you so much, Ron. And sorry for interrupting you. I didn't know you were muted while you're talking. Oh, sorry, Mike. Go ahead.
You don't have to be sorry. Bob, other states have really totally abolished pretty much cash bail. And we need to understand best practices and evidence-based practices, and that it's trending that way. So I think that as much as I support the current bill, I don't support it because we're not bold enough or not crisp enough to do it. What is it, Bob? New Jersey, DC, where Chicago? Where else are we? Go ahead.
I'm looking at some of my notes here. The District of Columbia releases 94% of the people who are arrested without bail. And of those released, 91% make their scheduled court dates, and 98% are not arrested for a violent crime while awaiting trial. In 2017, New Jersey basically eliminated cash bail. And in the most recent report from the Supreme Court Justice of the state, he said that the system is working really well, and that the number of people who don't show up is consistently very low. And then I think the real landmark is in February of 2021, the state of Illinois completely eliminated all forms of cash bail, completely for everything. And then wisely, I think they're going to spend it after this year and next year, they're spending the time going around to educate the judges on what is the intent of this bill and how should it really be applied, and doing a lot of training and educating so that the bill can be implemented in the way it was intended. And I think those are models for Hawaii and other states.
Can I add something? And also it's asking Bob something, because I know you are really good at stats and data. And in comparing Hawaii to other states, I think it's important to be mindful. We are low, and you can probably quantify how low we are with respect to violent crimes in comparison to many of these states that have implemented reforms. And even with kind of current news stories, which are scary, and certainly we do not want anybody to be the victim of any type of crime, especially a violent crime. I think it does not affect the data that Hawaii remains low as far as violent crime rates. Is that accurate? I know you're the data man.
Yeah, I don't have the exact numbers. I haven't looked at it in maybe a year and a half. But yeah, we have a pretty, we are a safe state, all in all, a very, very safe state. And in fact, there are these databases that employers, these companies maintain, so that if you're thinking about moving or taking a job in Hawaii and you want to know, is this a safe place or as compared to other places, you can go to them and they got data on it. And Hawaii always ranks very, very high. They'll tell you, of course, what neighborhoods you should live in and which ones you should avoid. But yeah, it's just I don't know, at some point in, maybe when the other people chime in, I would really like to know what people think as to why we are so conservative, why we haven't moved. A liberal state, a blue state like Hawaii hasn't moved farther, faster when it comes to prison reform and bail reform.
I'm also definitely questioning that, Bob. And I'm just going to move on to, I think this would probably be my last question for everyone.
Let me
Oh.
jump in. Can I jump in quickly?
Yes, of course.
Bob asked the perfect question. How many jury trials have Ron and I and other judges tried? And every guilty verdict, I go in and debrief them, thank them. They're one of 10 out of 200 countries. The court of public opinion has spoken. Our jurors do not usually want the defendant locked up forever or at all. Once they hear all the facts and all the pressures, they will tell me, for God's sake, don't put him in. But sometimes we have to, so I just want you to all understand, we don't live in a lock them up, throw away the key community. Where does that come from? It's the press, it's political, whatever it comes from. But we restorative justice says that we try to make the person competent. We don't want them to recidivate, and we want to get them back where they're productive. Thanks.
And I'm gonna now follow up again, and I think I want to push back just a tiny bit. I absolutely agree with what you just said, but I think when folks are talking in abstract, I tend to hear lock them up and throw away the key. But whenever there is a personal connection, whenever they serve as jurors and feel the impact of what the courtroom is, what's going on, there's a tangible life involved, that's when opinions change. But when folks are thinking just generally, they lose kind of the humanity, they lose their own sense of who we are as a society and what makes us a community.
And that was great. Thank you so much, everyone. And just very, very quickly, I know we already kind of touched on it, but could anyone talk about judicial discretion and how the power is given to judges in Act 179? And is Act 179 being used by judges today? If anyone could. Okay, no, that's okay. I'm going to go to another one then. This is probably my last question then. Recently, there's been a lot of very dehumanizing talk, especially with recent news that we have like a rising crime in Hawaii. For example, the murder that happened at Kapolei Police Station that directly involved bail and sparked very harmful notions that bail protects us from dangerous and violent people who are often just lacking resources like housing, education, healthcare, food security, employment, other services, and communities of care, as many of you have touched on already. How can we combat these harmful narratives, pushing against and slowing the implementation of meaningful bail reform and its eventual elimination? If anyone wants to take that on, that was kind of big.
Well, if nobody's going to jump in, I will. I think if the question is really important, because the way we understand things really is through stories. I mean, I think all trial lawyers will tell you that if you can tell a good story, that's the way to make jurors understand what you're talking about. And we don't have a way to tell the stories of the people who are incarcerated. But if you sit down and talk to someone like Minda about the people whose lives have been impacted, and she deals with these people all the time, you see them in an entirely different light, and you begin to understand who they are and how they got in this position and why they did what they did, even though it was a bad decision, it was bad judgment, it hurt people, but it becomes much more comprehensible. There was an article in the paper, I'm sad to say, it was I think about 2 days ago, on the new jail and the issues around that issue. And I was quoted in the article. And then I read it with great interest, and then I scrolled down to some of the comments that people had made, and they were really disgusting. I mean, it's hard to believe that people would say this. They said, well, Hawaii is just a catch and release state, and basically suggested we just ought to kill these people and sell their body parts to China. I mean, I'm serious. It was just appalling, but there is a lot of hatred going on, and I wish we did have a more systematic way of addressing it and telling the story of all the people who have gone to, who've been in trouble and have succeeded and have been successes. And I know some of them. And, I wish I could use their stories, but they're ashamed of, what they did, and they don't want it there, out there. But it's really important. We need to shift the narrative. I don't know how to do it. I'd start doing it if I could, but it's so important.
Thank you so much, Bob. Did anyone else want to add on to that discussion or question? Okay, that's perfect. Thank you so much. Now I have one more question again. How can we reimagine a vision of public safety, and what does true safety look like, especially in the frameworks of transformative and restorative justice, and uplifting the voices of those directly impacted, as Bob touched on?
Can I just say something very quickly about that? In 2017 and 2018, I was vice chair of the Hawaii House Concurrent Resolution 85 Task Force on Prison Reform, and which was chaired by Justice Mike Wilson. And we met for 2 years, and we worked on that question, really. What does a fair and just correctional system look like? And how can we have that and make our communities safer? And we came up with a report. It's 116 pages. It's based in large part on the fact that 4 members of the task force that wrote the report went to Norway and looked at the Norwegian correctional system, which is generally recognized as being the best in the world. And we saw over there a vision like the people in the United States cannot really imagine. It's a system where the word for guard in Norwegian really translates best as a caregiver. I mean, that's the way they see the people work in the prison. If you want to go into the prison, you've got to spend 2 years being trained to go in at an academy. You get full pay, of course, but they want you to study psychology. They want you to study human rights. They want you to study de-escalation. They want you to study all these things 2 full years before you're allowed to get into the prison and really work with the prisoners. The way they treat them is just like human beings. They don't put the cells are large. They have a big window. They have a bathroom. They have a sink. They have a toilet. They have a little flat screen TV, they have a refrigerator, and the inmates all have a key. So when they go out to work and do the other things and go to school, they lock up their room and go out. If we look around at the best systems in the world, the answers are all there. It's not rocket science, and the Norwegians are so willing to share what they've learned with others in terms of how you design these systems that really work, because they have a recidivism rate of 20%. And they really care for their prisoners, and they really treat them well. And they feel that they failed if there's recidivism and somebody comes back. They look at it as their own personal failure, not the inmates. That's just the attitude that they bring to it. So I would simply say, in terms of how can we do it, take a look at the HCR 85 final report. It's 116 pages long. It's got a lot of good ideas. It talks about a lot of the problems, and it's not a roadmap. It's not that detailed, but it's a vision of a better correctional system, one the world recognizes as being the best. And I don't think we should rest until Hawaii has come to the point of saying, yeah, that's what we want. That really works. That treats people good. That reflects our values. We're going to do it. Let's get busy. That's my 2 cents worth.
Mahalo, Bob, and mahalo to Kamaile for dropping that in the chat. That was super great. Thank you. Minda, I know you unmuted for a second in the beginning. Did you want to also speak on that?
Sure. I mean, I think that what I was going to add to what Bob had previously said, which is telling stories, is that is certainly a critical way to impact swaths of the population that currently aren't exposed to the folks that I work with daily. But in addition, there has to be data, which is exactly what Bob pivoted to, right? In the task force report, which is what I was going to say, that has to move individuals that are making these decisions. Policymakers, we cannot be relying on sensationalized stories to drive the policies. That is just an irresponsible. And I think generally, when you hear that concept, we're going to rely on data. We're going to rely on good information. We're going to rely on smart approaches that help us to save money, that help us to streamline our efforts. You always hear work, what do they say? Work smarter, not harder. And like, if you're like in some business, I don't know, I've never been in a business, but they have like phrases like that, right? They like get you going like that. I mean, the same has to apply with policymakers, with those that hold the power, whether they be legislators or the courts or whatever else has the power to implement change. Like the individuals in charge just have to be convinced that relying on data, relying on good, solid information, relying on tried and true methods from different states, from different countries is absolutely the way to the future. So again, I think it's like both telling these stories, but also just let's be sensible, and whenever I do have the opportunity to talk, whether it's amongst like-minded folks or not, I mean, I have 2 children that are both adults and have circles and that are nobody cares about criminal justice reform in many parts of my life. I when appropriate with the right intonation, I always try to interject the humanity into the work that I do and remind folks of some of the stories that I have, and I'm always telling people, like, I live in this community. My mom lives in this community. My children live in this community. There's nothing that I do or say that I have, the only desire I have is to make us a safer place, right? Why would I want, with the stakes that I have for myself and my family, to make us a less safe place? And yet I hold these visions of what it means to have a just system that aren't the lock them up and throw away the key for obvious reason. And so, I mean, it has to be these storytelling plus the data, but the obstacle that we are currently all kind of grappling with is, how do you amplify both of those messages? Where is the megaphone? Who is the courageous leader? Who is the one that is going to lead the charge in this new and better way, right? I mean, I'm not pretending that I certainly am a courageous leader. I say it with ease, like that's what it takes. But that is not an easy task. That's not an easy role to be. That's not an easy position to, you often lose friendships, you put yourself out there, and a number of other things can happen if you want to be that courageous leader. But certainly it takes that kind of efforts on all these fronts. And I don't know, I'm with you, Bob. Where do we get the megaphone?
Yeah, well, one thing that, I had the opportunity to meet with some of the people who spearheaded the bail reform in Illinois, which I think is now the best bail reform bill going. And it was led by African Americans in the community and African Americans in the legislature. And they just said, these are our people. This is what's happening to us, and we're not going to put up with it. And they really did a heck of a job of organizing, because they still are a minority, but they did a terrific job. So I think that's one thing that we should look at. But also in terms of motivating people, and I wanted to give this statistic before, because before we start taking comments from other people. One motivator is maybe money. I just looked at the pretrial population statewide as of March 21, 2022. That was 7 days ago or so, and we had 918 pretrial detainees statewide in our jails, and they were costing us and are costing us $201,000 a day, every single day. Write a check for $200,000, 73 million a year. So if you're not, if you don't want to do it for the right reasons, consider your pocketbook. 200,000 is a heck of a lot of money, and that doesn't include an equal amount for parole violators. I mean, probation violators. There are more, almost as many as probation violators as there are pretrial defendants. Those two groups, who are basically, most of them are Class C felony or below, and 68% of whom are minimum or community custody. Those people do not need to be in jail, and those people are costing us an awful lot of money. And now that we're going to build a new jail, the new jail is going to cost us $700,000 per bed. And so if you're looking at 918 beds for your pretrial detainees, multiply 918 times 700,000, and you'll start to see how much it's going to cost to build the beds just to incarcerate these people pretrial who don't need to be. It's going to cost literally hundreds of millions of dollars that we cannot afford. So there's a practical approach as well.
I absolutely echo the both of you. And now I'm going to bring it to basically everyone else in the Zoom. And the same goes for everyone. Please, like Tadia is doing right now, please raise your hand if you want to ask a question, and feel free to ask. So Tadia, if you wanted to speak, please feel free to.
Oh, mahalo, aloha kako. This is Tadia Rice. Mahalo for recognizing me. I was just very happy to hear what Bob just said, because I think it's almost 6 times what we spend on incarceration than what we spend on school children. So there's so many incongruities and imbalances systemically that have to be changed. I don't know that I have any answers, but I can tell you, those of you who are asking for a mouthpiece or for a way to tell the story, I have been telling the story. I have a radio show. I have been at the prison at WCCC for 10 years. I've been working with the women, and of all things, it is the University of Maryland who has now invited me to come and bring my prison cell experience art installation to them in September. It's all about women's incarceration and what's wrong. It deals with cash bail, it deals with everything, really, everything that impacts women, at least. I have not gone into the male portion of incarceration because I've been focused on women. And Kat and Lauren and those of us who are on the Women Prison Project now, I totally agree and have been involved with the bills. And I'm surprised here that the bill is not, are more limited than I thought they were. So that is something that needs to be addressed. But I am very happy to be a mouthpiece. I'm very happy to write and tell the story. I'm a writer, that's what I do. Call on me anytime, anyone, and I will find ways to publicize whatever it needs to be. And it's just ironic that Hawaii is getting attention, a state prison system getting attention where there's only federal prison systems on the East Coast. So that's all I wanted to share and contribute. And thank you so much for this wonderful, wonderful Zoom meeting. I've really appreciated it. Mahalo.
Mahalo, Tadia. Thank you so much for sharing your mana'a. It's so valuable. And right before I get to you, Barbara, I'm so sorry, Kalamai. Alice, did you want to also share your story, if you're willing?
Can you guys hear me?
Yeah.
I'm not going to share my whole story because it's like really lengthy, and it's about my son being incarcerated, and having high bail and the effects on the family. Like my daughter had to take out a loan to get him out, and like I think it was Bob said that you don't get the money back. You know, that's the 10% portion. We don't get it back, but yet we still paying on the loan. You know, well, not we. I kind of say we, but my daughter and my son. Just happened he came on. He's doing really well. He got a job, doing security, but he has a support. You know, he's not being held in jail. Him being held, he could have been held in jail had my daughters got denied for the loan. You know, and she went several places and was denied because they asked what's it for, and then they automatically just shunned her because of the stigma attached to people who's incarcerated. But I don't know. I feel this tugging in my spirit. I've had it. My son is home. He still got to go trial, but I still have this tugging in my spirit. And I hurt for other families that feel powerless and don't know what to do and don't know where to turn. Because I didn't know if my son was going to make it home alive because, you know, things happen in prison and the stories are covered up. And that was my fear. And that's why we scrambled to try and get him out. But given this opportunity, he did good for himself, you know. Yeah, I just want to be a vessel. Whatever it is, you know, whatever I can do. And my son's willing to share, even if he share his story too.
Aloha nui e, Alice. Thank you so much for sharing your story, and it's so nice to see you again tonight. Thank you for coming. Barbara?
I wanted to ask, it's probably moot now, but I was wondering why the governor did not sign the bill last year. As I recall, it went all the way to his desk and he didn't sign it. And I cannot remember why, because I thought that was a better bill. I thought that at the time. Now I probably need to compare them. Anyway, I'm sure that some of the experts will know why that happened. Or as I said, it's kind of moot because it's no longer an issue. But I was just kind of wondering why he didn't sign the bill.
That's a good question, though, Barbara. That's a really good question.
It is a good question. That's why we don't know the answer. So good.
Thank you. That's a really great question, though. David?
Yeah, aloha, everybody. Hi. Thank you for the message here today. It's resonating with me very much on many levels. I was invited by a classmate of mine, Kiki, to shout her out. I appreciate the invite. But I have a lived experience being incarcerated and having to deal with bail and not getting bail and for a pretrial offense. I'm in recovery today. I'm also in the last semester of my master's program at UH in social work. And part of the reason why I got into social work was because of my experiences, you know, being addicted to drugs. And as a result, you know, having to steal to support my habit, not having to, but I chose to steal. And as a result, I, you know, was incarcerated, and all the trauma and things that I experienced in while I was incarcerated left a indelible mark on me. And just the things that I've witnessed, just how broken the system is here, and just nationally. It's not just Hawaii, and but like I would love to be a part of, you know, the solution now. Now that I'm in recovery and I'm going to school, and you know, if in any way that I can, you know, I'd love to share my story. And so Kiki has my information, and I've also been in contact with Cassie, I believe, and who I guess did Alice's story, and I'm going to be doing the same. So yeah, I just wanted to mention briefly. I will go into depth about what exactly happened with me in the story, I guess, but I think now, for time's sake, just leave it at that. I just wanted to introduce myself and say that I'm very much on board with this program, and I want to be a supporter and advocate for it. So yeah, nice to meet you all.
Thank you.
Yeah, thank you, David. Thank you so much. And it's so wonderful to hear everyone's stories. And they're so heartfelt. I'm a crier. I'm not going to do that tonight, but thank you so much for sharing, everyone. And very quickly, not to put any pressure on you, Kat, but I was just wondering, since you're here, hi, if you wanted to share anything about bail, especially since you had such an amazing article in Civil Beat that just came out a couple days ago. Oh, okay. I can't hear you, but you're muted.
Okay, can you hear me now?
Yes.
All right. So I was just answering Barbara's question. So it wasn't the bail bill from last year didn't make it to the governor's desk. It got swallowed up by the conference committee machine. So they did have a conference committee, but they couldn't reach an agreement or something. And since we work on a biennium, our legislature works in 2-year chunks. So this was the second year of the biennium. So the bill carried over from last year. So we're kind of hopeful that JDC, that was a supporter of HB 1260, we're hoping that he'll fix the problems with the bail bill. One of the other provisions that was taken out is anybody, it removes the discretion of the Director of Public Safety to release people whose bail is $99 or less. And that was removed. And that's really sad to me, because that says that when people are really struggling, we're going to house them in the most unaffordable housing in Hawaii, $219 a day. It is insane what we're doing when there are many, many options we could do other than bail. I'm so grateful to Judge Ibarra. He's been such an asset on the Oversight Commission. So I think there's lots of things we could do. You can look up Pretrial Institute. They came up, my testimony for tomorrow, I list some of their alternatives, which, you know, are things that are common sense. Just like Judge Town was saying, why are we over criminalizing people? Why are things that used to be violations or petty misdemeanors, why are they felonies? What is going on? So we need to take responsibility that we got here because of bad policies and undo them. We can do that. So I'm very positive, and I believe that we can change it. This is not who we are. Okay, I'm off my soapbox. Hi, Minda.
Thank you so much,
everybody.
Thank you. Ron and Mike, did you have any other closing thoughts about this or anything, or with the Oversight Commission? Yeah, go ahead, Mike.
Well, from my perspective, anybody who's in the custody of someone else, be it kids or people in the hospital or people charged with crimes or in the prison, it's a fiduciary situation. We ought not to harm them. In medicine, we call it iatrogenic disease, the disease caused by the care. And I call it, when I teach my courses, jurogenic disease. We bring someone in to be fair, and we end up making it worse. So I think we need to flip the script a little bit and realize we have a fiduciary duty. And that runs against what some people think, but not what my jurors. My jurors understood. And we're, as I say, one of 10 countries out of 200, we have citizen jurors, and they know. And many people won't tell you because they're, but I would give them all a certificate and thank them because they're judges of the facts. Thank you.
Okay, may I?
Yes, of course, Ron. Go ahead.
Okay, from my perspective, in order to effectuate change, to convince the policymakers, the legislators, the elected officials, the people must be involved, like I said in the beginning. It has to be a fair system. The people must buy in. The people must convince the policymakers, this is what we want, or we will not vote for you. Then you would get their attention for sure, because certainly they want to do, they should represent the majority of the people, and the people's will should be followed. Now, we have a lot of expertise here in this group, and what we need to do is basically like everything else that you need to effectuate change with is educate the public. You know, if the public doesn't know enough, you know, they won't buy it. They won't buy into it. They'll just go with the sound bites, right? Lock them up, throw away the keys, but they don't even look beyond that. You know, I give an example is, you know, we have a big problem in Hawaii with drugs. So we started the drug court in Third Circuit. And when we started the drug court, you know, it was said there's stigma to people that use or are addicted to drugs. It used to be the traditional way of addressing drug addicts was the criminal way. And you take drugs, you're a criminal. Recently, this has moved to the holistic approach, to the medical approach. Basically, drug addiction is a medical issue. So when we started the drug court, we basically treated the drug addicts, you know, very kindly, offered them services, and we had to educate the public. I recall when we went out to do a public project such as collect food for the food bank, and the drug court participant went out and tried to solicit money or food from the food bank, we had comments like, "You belong in jail. You don't belong out here." You know, so it was in the beginning, it was tough. So the drug court did more community project, entered parades. And when I tell them, you got to get a job, tell your employer that you are in drug court. And we honored the employer with Employer Day, give them awards. And pretty soon we had the community changed. And because we had a community change, they wrote to the legislature, and we had the drug court funded by the legislature. So my point is, you got to educate the legislature from the people's perspective. That's all. Thank you.
Oh, that was perfect, Ron. Mahalo. People power. I'm very much for that. Minda and Bob, did you also have any closing thoughts? No pressure.
Oh, Bob, you're muted.
Just wanted to say, I think it's been a great discussion. I learned a lot from everybody who's here and from the comments that the people made. And you know, thank you for inviting me. It was really a good experience.
Thank you for joining us. Sorry, Minda.
No, I also want to thank everyone that is present, thank the fellow panelists and the organization. But I mean, I think the message that we just heard from Judge Ibarra is really an apt one to leave it on. So I don't want to. Yeah. I don't want to muddy that one.
Me too.
That was perfect. Thank you so much. And I think we're proud. Thank you so much to everyone, and especially to our incredible panelists. Thank you so much for joining us and taking the time to spread your mo'olelo and your mana'o with us. Very quickly, if you would like to take action and help us organize to reform cash bail, I'm going to list out some actions that you can take. So first, you can sign up for our Faith Action Transformative Justice Task Force phone to action text alerts, and using the link that I think will be dropped in the chat or will be sent out in an email after this. We'll be alerting you with opportunities to submit testimony on bail reform bills and other transformative justice related issues. Secondly, our amazing Hoa and Faith Action organizer, Cassie Chi, is currently running a cash bail campaign during Lent and is hosting a Reimagine Fund, which aims to raise $8,760, which is roughly the same amount it takes to incarcerate one person in Hawaii for 40 days. 10% of this is going to help our advocacy to reform the cash bail system, and 90% will be invested in organizations that support those coming out of incarceration and culturally grounded practices. 3, you can learn more about our correctional systems and the work we do here at the Transformative Justice Task Force on our website, faithactionhawaii.org/transformative-justice. And you can also get added to our email list for resources and follow us on social media at Faith Action Hawaii. And lastly, tomorrow morning or before tomorrow morning, please submit written testimony on HB 1567 HD1 before its last committee hearing tomorrow, Thursday, March 31st at 9:30 a.m. and help us advance bill reform in Hawaii State Legislature. And I think that all of this information is going out after this. So mahalo nui to everyone for talking story with us, and especially to Ron, Minda, Mike, and Bob for sharing such valuable insight into cash bail and for giving us hope into a community people power based solution to end cash bail and mass incarceration. Mahalo nui to Lee, Soon, Cassie, and Kiki for being amazing, and mahalo nui to everyone for coming and participating tonight. And we really, really appreciate all of you and everything you do to help us build towards a brighter, better, and free Hawaii. And again, this recorded event will be uploaded to Facebook, Faith Action's Facebook page at Faith Action Hawaii. So please share it out and ask your loved ones to join the fight. And that's all I have for you. Mahalo nui, everyone. And I hope you all have a great rest of your evenings. Thank you so much.